Shop, Distributive and Allied Workers and others.
I will ask Lord Burrows to explain this judgment.
This case raises important questions as to, first, an employer's right under contract law to terminate an employee's contract of employment by giving the requisite notice to the employee, and secondly, as to an employee's remedy for breach of an employment contract. In 2007, Tesco Stores Ltd decided to close certain of its distribution centres, to expand or restructure others, and to open new sites. Tesco wanted to incentivise existing employees at the centres being closed to relocate to another site. It therefore entered into a collective agreement with its recognised trade union, the Union of Shop Distributive and Allied Workers, USDAW, under which Tesco agreed to provide what was called retained pay to employees who agreed to relocate. The right to receive retained pay was then incorporated into the relevant employment contracts as an express term. The retained pay term stated that retained pay would remain, quote, a permanent feature of an employee's contractual entitlement, subject to certain qualifications. As is commonplace, a separate express term in the employment contracts gave Tesco a contractual right to dismiss the employee without cause, provided a specified period of notice was given to the employee. In 2021, Tesco wanted to end retained pay. It therefore informed relevant employees that if they did not consent to the removal of their right to retain pay, they would be dismissed with the requisite notice and offered re-engagement. The re-engagement terms would be identical, save for the removal of the retained pay term. In other words, Tesco embarked on what is often referred to as fire and rehire. Together with USDAW, several employees in receipt of retained pay applied to the High Court seeking declarations as to the correct meaning of the retained pay term and seeking an injunction to restrain Tesco from terminating their employment in order to remove the retained pay term. Mrs. Justice Ellenbogen found in favour of the employees and granted an injunction, but her decision was overturned by the Court of Appeal. USDAW and the employees therefore appealed to the Supreme Court. The Supreme Court unanimously allows the appeal. The leading judgment is given by myself and Lady Simler, with whom Lord Lloyd-Jones agrees. Lord Leggett and Lord Reid give concurring judgments. Tesco argued that the retained pay term meant that the entitlement to retain pay would be permanent only for the duration of the contract. That is, it was subject to Tesco's unqualified right to dismiss on notice. This argument was rejected as giving no substance to the express promise that the entitlement to retain pay would be permanent. The correct interpretation of the retained pay term is that the right to receive retained pay continues for as long as employment in the same role continues, subject only to the qualifications within the retained pay term. It's inconceivable that the objective mutual intention of the parties was that Tesco should retain a unilateral right to dismiss the relevant employees for the purpose of removing the right to retain pay. That would flout industrial common sense. The correct legal analysis is that Tesco's right to terminate the employment contract by giving the requisite notice is qualified by a term implied by fact that Tesco's right to dismiss cannot be exercised for the purpose of depriving employees of the right to retain pay. Applying the traditional tests for implied terms, that implied term is necessary for business efficacy, or alternatively, it is so obvious that it goes without saying. The existence of that implied term is supported by analogous cases, including cases in which employment contracts providing for permanent health insurance benefits were held to contain an implied term to the effect that the employer was restrained from dismissing the employee in order to deprive them of those benefits. Importantly, Tesco's right to dismiss for any reason other than to remove the right to receive retained pay remains entirely unaffected by this implied term. Having decided that Tesco was acting in breach of contract, what then was the correct remedy for the employees? The employees sought an injunction restraining Tesco from acting in breach of the implied term by dismissing them. But in practice, such an injunction would amount to indirect specific performance of Tesco's obligation to continue to employ the employees on retained pay terms. And as a general rule, specific performance will not be granted of an employment contract. However, we have decided that exceptionally, an injunction amounting to indirect specific performance is here justified because, first, damages, the usual remedy for breach of contract, would be inadequate, and secondly, there was no breakdown of mutual trust and confidence. Damages would be inadequate because assessing those damages would involve significant speculation, uncertainty, and additional costs. And traditionally, damages would not cover non-pecuniary loss, for example, loss of job satisfaction, suffered by the employees in being dismissed. And there was plainly no breakdown in Tesco's trust and confidence in the employees because they were being offered immediate re-engagement in the same roles. The injunction granted by Mrs. Justice Ellenbogen is therefore reinstated. Lord Leggatt, in his concurring judgment, gives additional reasons why the implied term arose in this case, and Lord Reid, in his concurring judgment, stresses his agreement with what myself and Lady Simler have explained about the relationship between the interpretation of the collective agreement and the interpretation of terms in the employment contracts incorporated from that collective agreement. The appeal of USDAW and the employees is therefore unanimously allowed.
The court is now adjourned.